So the question of diversity in international arbitration towards a more inclusive approach, we have several key questions to be answered today. One is a lack of diversity in commercial arbitration blocking change and preventing new entrants? Is it a bar, so to speak? Can diversity enhance the perceived legitimacy of the dispute resolution system itself and the quality of the process and outcomes by encouraging greater efficiency, as well as facilitating new perspectives on the dispute and the dynamics therein? Will an international arbitration system that embraces differences of legal cultures and bridges the gaps of Islamic, civil, and common law, is it likely to be in a better position to serve users' needs and to handle cross-border disputes? So we're going to look at the root causes and potentially some of the solutions related to cultural, gender, and other roots of diversity themselves. And finally, we're also interested in looking at the whole question of youth and ethnical diversity as well. Ultimately, perhaps Queen Mary's Professor Stavros Brikoulakis, who leads the research of the arbitration survey that no doubt all of you are quite familiar with, the user survey, he argued that there has to be a real will to change and a belief that it will improve the arbitral process itself. And the quote he gave at his presentation was, "Unless we are convinced that diversity brings about a better decision-making process, we are not going to shift from the current status quo, where diversity is an aspiration, to a stage where we are actually convinced that we have to do it to improve the system." So with that, and to make your individual determination, let's hear from our distinguished panel. The first speaker is someone who's very familiar to everyone across the region, and in fact around the world, is Professor Dr. Nella Camara Bayad. She was the founding partner of the Bayad law firm, professor of law at the Lebanese University, author of the Law of Business Contracts in the Middle East. She's a member of the ICC board, companion of the Chartered Institute of Arbitrators London, former president of the CIRB in 2017, and sits on the ICSID panel of arbitrators and conciliators. She's a council member of the ICC's Institute of World Business Paris, board trustee of the Cairo Regional Center for International Commercial Arbitration, member of the LCIA Court London, former commissioner of the UN Compensation Commission Geneva, former chair of the Arbitration Committee of the IBA, and very, very interestingly for many of us here, she's a member of a rather considerable innovation, China's International Commercial Expert Committee of the Supreme People's Court. So she's been involved in more than 100 arbitrations as counsel, as an arbitrator, and she's also worked under the rules, and this is important for all of us because her diversity of experience with the rules ranges from ICSID, ICC, LCIA, Singapore, DIAC, Cairo, Bahrain, DIFC, LCIA, UNCITRAL, and others. And with that, I invite Dr. Nella Camara Bayad.
James, many thanks for your very kind introduction. أصحاب السمو والمعالي والسعادة والفضيلة، أيها الزميلات والزملاء، أيها الكرام، يشرفني ويسعدني أن أكون أحد المشاركين في المؤتمر الدولي الثاني للمركز السعودي للتحكيم التجاري، وأن أشهد على ما قام به المركز خلال السنين الماضية وخاصة السنتين الماضيتين من إنجازات جبارة تؤكد النجاح الملموس للرؤية التي وضعتها المملكة العربية السعودية في دعم التحكيم التجاري، والتي نفذها المركز في وضع الدعائم الأساسية للسير قدماً لوضع المملكة على خريطة التحكيم الإقليمي والدولي. وهذا لا يتحقق إلا بما قامت به المملكة من إصدار تشريعات حديثة، ومنها قانون التحكيم لسنة 2012، ونشر ثقافة التحكيم من خلال اعتماد دورات تدريبية للعاملين في مجال التحكيم والطاولات المستديرة مع القضاة المولجين بالتحكيم، وذلك بالتعاون مع Chartered Institute of Arbitrators، المؤسسة الرائدة لنشر ثقافة التحكيم الذي كان لي الشرف أن أرأسها دولياً سنة 2017، وأستذكر منذ عدة سنوات وبدعم المدير العام الموجود هنا السيد أنتوني إبراهام أتينا واجتمعنا مع وزير العدل السابق من أجل دعم المملكة في نشر ثقافة التحكيم وقيام الدورات التدريبية في اللغة العربية. وموضوع محاضرتي اليوم هو يتعلق بفرص التحكيم الدولي في التوفيق بين النهج المختلفة في الشريعة الإسلامية والقانون المدني والقانون الأنجلو ساكسوني. ومن هنا سأعطي المحاضرة في اللغة الإنجليزية بعد هذه المقدمة باللغة العربية. Ladies and gentlemen, dear colleagues, I'm switching to English, and I'd be very pleased to answer questions in Arabic and English after my presentation. I'm going to address today the potential of international arbitration to reconcile the different approaches in Islamic, common, and civil law traditions, which are all part of the Middle Eastern legal landscapes. By way of general background, as you may know, most of Middle Eastern countries are largely inspired by the civil law tradition. The principles of civil law, which are the core of most Middle Eastern legal systems, are primarily derived from Egyptian law, which in turn was heavily influenced by the French civil legal system. In Lebanon, similarly to Egypt, the statutory rules regulating civil and commercial matters were directly modeled on formal French laws. Some countries of the region, some as Saudi Arabia or the Sultanate of Oman, have developed legal systems directly based on the principles of Islamic Sharia, on Islamic law, and do not have a civil code. Other countries, such as the United Arab Emirates, UAE, or Qatar, and also Jordan, have developed mixed legal systems with influences from both civil and Islamic legal traditions. For historic reasons, common law has much less impacted Middle Eastern legislation. It is mainly with the increased popularity of international arbitration in the Middle East and the proliferation of arbitration institutions in the region that common law has infiltrated the Middle Eastern legal landscape. This has been done first through the establishment of specific zones governed by a common law system, such as the Dubai International Financial Center, DIFC, and the Qatar Financial Center, QFC. This dichotomy was further enhanced through the practice of international arbitration in the Middle East itself, which implies the interaction of arbitrators and counsel from both civil and common law backgrounds. The choice of English law as the applicable substantive law by Middle Eastern parties, even when the arbitration has no connection with the United Kingdom or English law whatsoever, is another noticeable phenomenon which has contributed to integrating common law in the region. The legal diversity characterizing international arbitration is as much a source of enrichment as it is sometimes a source of practical difficulties affecting both the arbitration procedures, and arbitrators' approach to the application of substantive law. Because justice, in my view, is not dispensed in the same way everywhere around the globe, the preferred way of applying the law in one legal system can be inconceivable in another legal system, which can be a source of misconception and misunderstanding. Thus, Islamic, common, and civil law traditions, which are all susceptible to interacting in international arbitration proceedings involving Middle Eastern parties, are marked by considerable procedural and substantive differences, of which I will give you a brief overview. Starting with procedural differences, the international arbitration procedure itself has been influenced mainly by common and civil law legal tradition. In my view, one of the main differences between the two legal traditions relates to the role of the judge as opposed to the role of the parties. In the common law adversarial tradition, the judge remains relatively passive throughout the proceeding. The common law evidential process is also party-driven. That is, the disputing parties decide what fact and expert witness evidence they wish to serve in support of their respective cases and are in charge of interrogating the witnesses and experts they call. Conversely, the inquisitorial approach underlying the civil law tradition draws on the Roman adage of Fura novit curia, the courts know the law, whereby the judge takes an active role in the fact-finding process and is responsible for establishing the truth. This divergence of approaches results in important differences relating notably to disclosure. While common law systems favor a broad party-initiated disclosure, party-driven discovery is a concept which is foreign to civil courts, which view the judge as the main actor in the gathering of evidence. Another key procedural difference between common law and civil law relates to the weight given to oral testimony. Common law practitioners tend to consider that oral testimony, through the physical presence of a witness, affords the judge the opportunity of observing the witness' demeanor. Can one see as also a useful indication of a witness's truthfulness and therefore a source of essential complementary information to understand the parties' cases? On the contrary, because the parties are potentially swaying the truth to their advantage, statements made by the parties and or their witnesses or experts tend to be treated by the civil law judges with suspicion. Moving to the substantive law differences. Islamic, common and civil law tradition involves the application of different legal principles to a same set of facts, which can lead in certain instances to totally different outcomes in terms of liability and damages. In contract law, these differences relate notably to core principles governing the formation of contracts, but also the principles governing liability in case of breach of contract. Changes of circumstances after the conclusion of the contract, too, will be approached differently depending on the applicable law. The theory of force majeure has been developed in civil law countries, the concept of frustration in common law countries and of unforeseen circumstances in most parts of the Middle East. Important divergences also concern the award of damages and interest, which are limited in Islamic law by the concept of riba or usury, prohibiting unjust, exploitative gains made in trade or business. A misunderstanding of these different legal concepts can be a source of increased time and costs affecting the arbitration proceedings, which can be which can be threaten its sustainability as an effective dispute resolution mechanism. For this reason, a harmonization and reconciliation of the different approaches in arbitration, in international arbitration, is, in my opinion, not only desirable, but also necessary. I will address how such reconciliation is possible. First, through the application of national arbitration laws and the application of international arbitration rules and guidelines. I will then address the reconciliation of different approaches through the practice of international arbitration, and finally, through education and training. Perhaps the first step towards reconciliation of the various legal traditions was achieved through a harmonization of national arbitration laws in various jurisdictions, favored by the adoption of multilateral conventions widely ratified worldwide. Both the New York Convention and UNCITRAL model law have played a crucial role in such harmonization. In our region, most Arab countries have ratified the Convention on the Recognition and Enforcement of Foreign Arbitration Awards, and most of them have adopted new arbitral legislations which are inspired by the UNCITRAL model law. Institutional arbitration rules have also served as an important tool to reconcile the procedural approaches in different legal traditions. The Saudi Center for Commercial Arbitration Rules of 2016 are the first commercial arbitration rules to be released in the Kingdom. The SCCA has established partnerships with institutions from common law jurisdiction, especially with the International Center for Dispute Resolution, ICDR, of the American Arbitration Association, which participated in drafting the SCCA arbitration and mediation rules, as well as codes of ethical conduct for arbitration parties and staff. The rules are mainly based on the UNCITRAL arbitration rules, but contain a number of significant amendments to these rules, which include the following. Under the SCCA rules, the tribunal shall, without prejudice to the rule of Sharia, apply the rules of law designated by the parties as applicable to the substance of the dispute. Further, the SCCA rules, like the other rules, state that the arbiter tribunal should decide in accordance with the terms of the contract, taking account any usage of trade applicable to the transaction. However, a tribunal applying the SCCA rules should do so without prejudice to the rules of Sharia and any international conventions to which the kingdom is a party. This is Article 31.4 of the SCCA rules. Unlike the Uncitral, the SCCA rules do not require pleadings, and the Arbitral Tribunal has a wide discretion to determine its own procedure, including deciding preliminary issues and bifurcating proceedings. The SCCA rules states that the Arbitral Tribunal shall take into account the applicable principles of privilege, including those involving the confidentiality of communications between lawyers and their client. However, they add that when the parties, their counsel, or their document would be subject under applicable law to different rules, the tribunal should, to the extent possible, apply the same rules to all parties, giving preference to the rule that provides the highest level of protection. The SCCA rules thus represent a mix between the civil and common law traditions characterizing the Uncitral rules and should be read in line with Sharia principle, that including elements of Islamic law. And now I echo what has been said by Toby Lando, that we should also take into consideration the applicable law to the countries and the characteristic of the rules and public order related to every country. This is my view also. The BCDR AAA arbitration rules of 2017 also serve as a good example of such rules in the Middle Eastern region. The SCCA arbitration rules of 2011 are also based on the Uncitral arbitration rules of 2010, save for a number of modifications, and are a mix of both civil and common law procedures. More generally, most international arbitration rules have found a middle ground approach which respect to procedural common law and civil law approaches. This applies, inter alia, to the rules governing evidence, such as the weight to be given to oral versus written evidence. Thus, while documents are preferred form of evidence in international arbitration, arbitration practitioners coming from both common law and civil law background largely agree that witness evidence brings additional information which is very helpful for an arbitral tribunal's quest for truthfulness. Oral testimony is seen as important complementary evidence to fill in the gap left by documentary evidence and to bring new elements which can guide tribunals in their decision-making process. Arbitral tribunals, therefore, follow an approach very much similar to the taking of witness evidence in ordinary English court proceedings while giving considerable weight to written pleadings. Further, there is now an emerging consensus among experienced arbitrators and practitioners that a measure of disclosure of document is desirable in most international disputes. Thus, justice is almost always best served by a degree of transparency which brings the relevant facts before the arbitrators. Justice, as well as efficiency, is also best served by ensuring disclosure of the relevant facts sufficiently in advance of the witness hearing that the parties can prepare and present their cases in light of these facts. The International Bar Association has produced a number of rules, and most notably, the rules on the taking of evidence in international arbitration, known as the IBA rules of taking of evidence, which have been designed as a procedural compromise solution between the common and the civil law worlds in the presentation of evidence in international arbitration proceedings. The harmonization of approaches through arbitration laws cannot, however, completely erase the procedural and substantive divergences between legal cultures, which most often impact the advocates and arbitrators carrying with them the system in which they grew as legal specialists. This implies that arbitrators facing the inherent diverse backgrounds of parties and of their representatives in international arbitration should be ready to understand and apply rules which they are not necessarily familiar with. This also implies that counsel should be ready to adapt to different ways of approaching the legal proceedings from the other party's side. These interactions between legal cultures through the practice of international arbitration can nonetheless be seen as further steps toward the reconciliation of practices through the practical experience and knowledge gained from the exposure to different approaches. It is by experiencing different arbitration procedures in practice that counsel and arbitrator learn different approaches, become familiar with them, and are able to push towards the adoption of the middle ground approaches, taking into consideration the specificities of each legal procedures and creating a synergy throughout the differences that characterizing them. The civil common and Islamic law legal systems also each have their own characteristics in terms of substantive laws. Thus, when drafting arbitral awards, arbitrators should be carefully not to be influenced by their legal background when applying a law they are not familiar with. A number of key differences exist, notably in the approach to contract law, to damages, or to interest, and I will tackle a few of them. With respect to contract law formation, to begin with, under the common law system, a contract has no binding effect unless supported by consideration. The doctrine of consideration essentially means that a contract must be supported by something of value, such as the promise of a party to provide goods or services, or a promise to pay for goods or services. On the other hand, in civil law, a contract generally should have a lawful cause. Cause is the reason why a party enters a contract and undertakes to perform contractual obligations. Cause is different from consideration as the reason why a party binds himself to obtain something in return. The Islamic legal tradition also characterized by a number of specific principles governing the condition for a valid contract. When applying a law influenced by concept of Islamic law, arbitrators should take into account a number of restrictions imposed by the Sharia, such as the concept of gharar, namely an excessive risk, speculation, or uncertainty, which is one of the most strictly prohibited elements in Islamic financial contracts and transactions. Further, the concept of riba in Islamic law prohibits an imbalance and the parties' obligation. Such approach differs significantly from the common law approach, under which consideration need to be sufficient but not adequate. As mentioned earlier, diverging principles also apply to cases where changes of circumstances occur after the termination of a contract. While the doctrine of unforeseen circumstances under the majority of Middle Eastern laws allows the judges to revise a contract,
1 minute warning. Yes.
this would be inconceivable under the common law doctrine of frustration or civil law concept of force majeure, for example. The rules governing the award of damages and interest also differ depending on the legal tradition. As such, international arbitration offers to counsel and arbitrators the opportunity to get familiarized with different legal approaches to a same situation of facts, and as such, creates a dialogue and reconciliation between different legal cultures. Finally, a topic which is very dear to my heart, education, is one of the key elements for building a sustainable and harmonious arbitration framework in the Middle East. The Chartered Institute of Arbitrators Centenary Principles lists education as one of the core elements of a safe seat for the conduct of arbitration. The education of all involved in the arbitral process is indeed key to ensure a better understanding of different approaches to the procedure and the applicable substantive law. It allows to save time and costs by avoiding misunderstanding and mistaken approaches, and also promote the enforceability of arbitral award. Also, I would like also to say that education of judges is also major. Finally, the cooperation between arbitration institutions also is very important in the Middle East, and I would like to conclude that international arbitration has opened the door to a dialogue between different cultures and legal traditions, which are intermingled at different stages of the arbitral process. Committee gathering and events surrounding the practice of international arbitration further contribute to foster a better understanding of the similarities and divergence between different legal traditions and of their practical consequences. With time and practice, more homogeneity and a common language has been created by all actors involved in the arbitral process, who are gradually finding a middle ground between different legal cultures and thus promoting a reconciliation between them. Thank you very much.
Thank you very much, Dr. Nella. Next up, we have Ahmed Ofeli, an attorney and arbitrator with Ofeli Attorneys in Council. He served as a judge for more than 20 years, first appointed as judge of the Ariana Court of First Instance in 1995, and then at the Tunis Court of Appeal, the Premier Président's section, ruling mainly on arbitration cases. Before joining the Center at the Legal and Judicial Research, the CEJJ, where he spent 10 years drafting laws in the fields of investment, trade, procedure, and taxation. In 2011, he became legal advisor-in-chief to the President of the Republic of Tunisia and collaborated with the 3 successive Tunisian presidents. In 2015, he founded his firm, a law office that specializes in business law, including arbitration, banking, taxation, and commercial law. Mr. Ofeli has published several books, mainly on corporate and tax. He's also published numerous articles, commentaries, and surveys on arbitration in various topics. And I'm happy to say that, like Ms. Nella, he has also done a lot of trainings in the Kingdom and in the GCC. Welcome, Dr. Ofeli.
بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين. دعاني منظم هذه الندوة مشكورين إلى الحديث حول موضوع يطرح باستمرار وبشكل يومي، وهو موضوع التنوع في التحكيم الدولي وما إن كان هذا التنوع مصدراً أو معززاً لمشروعية التحكيم. للشروع في الحديث أو التفكير حول هذه المسألة سأروي لكم واقعة حصلت لي منذ فترة وجيزة عندما كنت رئيساً لهيئة تحكيم داخلي في تونس مع محكمين تونسيين، أحدهما عميد كلية حقوق والثاني قاض له تجربة بحوالي 20 سنة في مجال القضاء المدني والتجاري والجنائي أيضا. قبل الجلسة كنا بصدد الإعداد لكيفية إدارة الجلسة، فطلبت من المحكمين أن يعد ما لهما من الأسئلة لتوجيهها مباشرة إلى الطرفين. كان رد الفعل من أحد العضوين بالاستغراب والاستنكار، قال لي: تريد من المحكمين أن يسأل وأن يخاطب الطرفين مباشرة أثناء الجلسة؟ لا، هذا ليس مقبولا وهذا مخالف للمعمول به. أرى أن نعد أسئلة، نعطي هذه الأسئلة لرئيس الهيئة الذي هو أنا، وأنت من يسأل الطرفين. لا يعقل ولا يقبل أن يتخاطب المحكم مع الطرفين أثناء الجلسة. هذه الواقعة ذكرتني بواقعة أخرى عشتها منذ سنة 2001. كنا في زيارة، كنا وفدا رسميا في زيارة إلى المحكمة الأوروبية لحقوق الإنسان. حدثنا أحد قضاة المحكمة عن إحدى أولى الجلسات التي دارت لدى هذه المحكمة، حيث كان رئيس المحكمة فرنسيا وكان هناك قضاة من مختلف الدول الأوروبية. أثناء الجلسة وعندما كان الرئيس يدير الجلسة وينظم النقاش والمرافعات، أخذ أحد القضاة الإنجليز الكلمة مباشرة وسأل أو وجه سؤالا إلى أحد الأطراف، فأثار ذلك استنكارا واستغرابا لدى رئيس المحكمة الذي رفع الجلسة على الفور وتوجه إلى القاضي الإنجليزي وقال له: كيف تسمح لنفسك بأن تخاطب الأطراف؟ هناك رئيس للمحكمة هو الذي يخاطب الأطراف ويوجه الأسئلة أو ما شئت. إن كان لديك سؤال كان من الممكن أن تعطيني هذا السؤال أو تكتبه وأنا من يسأل الأطراف. فكان رد القاضي الإنجليزي أيضا بنفس درجة الاستغراب قائلا: كيف تمنعني وأنا قاض في هذه المحكمة من أن أسأل سؤالا أو أن أوجه استفسارا إلى الأطراف؟ إذن عالم القضاء أو عالم التحكيم يضعنا أمام هذه المسائل بشكل مستمر. هناك أشخاص من مختلف الفضاءات، من مختلف الثقافات، من مختلف أرجاء الكرة الأرضية، مختلفون في كثير من الأشياء، يلتقون تجمعهم قضية تحكيمية، ويأتي كل واحد بثقافة قانونية وثقافة اجتماعية، ويتصور أن الجميع متفق على أن الأمور تسير على النحو الذي اعتاده، فإذا به يكتشف أن الأمور لا تدار بنفس الشكل في كل أرجاء الكرة الأرضية، لأن البشر يختلفون في الثقافات والرؤى والقراءات وفي مناهج التعامل. في دراسة أنجزت سنة 2010 أنجزها معهد كوين ماري بإنجلترا، بيّنت هذه الدراسة أن المستجوبين يعتبرون أن التنوع هو ثالث عوامل نجاح التحكيم. 33% من الأشخاص يقولون أن التحكيم يكون أكثر نجاحاً وأكثر قبولاً وأكثر مشروعية كلما وفر مزيداً من التنوع. لكن في هذا الزمن يظل السؤال مشروعاً: هل وصل التحكيم إلى درجة مثالية من التنوع؟ وما هي هذه الدرجة المثالية من التنوع؟ ما يلاحظه أولاً هو أن من يطرحون مسألة التنوع هم في الغالب الأشخاص الذين يبحثون عن مكان في عالم التحكيم، الأشخاص الذين لهم موقع راسخ في مجال التحكيم يعتقدون في الغالب أن الوضع هو وضع عادي، وأن ما عليه الأمر هو الوضع الطبيعي، أن من يباشرون التحكيم كمحكمين أو كمحامين أو كمستشارين هم الأشخاص الأكثر كفاءة والأكثر جدارة، في حين أن الأشخاص الذين يبحثون عن مكان في هذا العالم يرون في الغالب أنه يوجد أمر يجب تصحيحه، أن تقاسم الأدوار داخل عالم التحكيم ليس متكافئا أو متناسبا أو عادلا بالشكل الكافي. هل وصلنا إلى الدرجة المثالية من التنوع في التحكيم؟ أولاً ما نلاحظه هو أن تاريخياً على مدى قرن أو قرنين قبل هذا الزمن كان التحكيم في الغالب ذا لون واحد. كان هناك محكمون في غالبهم أوروبيون أو أمريكيون، وكانوا في الغالب رجالاً ولم يكن هناك نساء في عالم التحكيم. وهذا ليس مفاجئاً، فتاريخياً يروي بعض مؤرخو التحكيم أو مختصو التحكيم الذين اهتموا بالجانب التاريخي أنه بالعودة إلى الحضارات القديمة كان التحكيم ليس فقط رجالياً، ولكنه كان أيضاً حكراً على صنف خاص جداً من الرجال. فلدى الإغريق مثلاً هناك باحث فرنسي هو فرانسوا ريغو يقول أنه في العصور القديمة كان المحكمون من صنف الملوك أو العظماء أو حتى أنصاف الآلهة بمفاهيم الميثولوجيا الإغريقية. محمد العربي هاشم أيضا يقول أن المحكمين مثلا في العصر الجاهلي لم يكونوا من عامة الناس، بل كانوا دائما من الملوك أو الأشراف أو الكهنة أو رجال الدين. إذن التحكيم كان دائما حكرا على صنف محدود من الأشخاص يتمتعون بمكانة كبيرة بحكم عدد من العوامل، منها العامل السياسي والاقتصادي والثقافي. العصر الحديث تميز بتكاثر القضايا والنزاعات، مما أدى حتما إلى توسع عالم التحكيم. فالأطراف أصبحوا يأتون من مختلف أرجاء الكرة الأرضية. عندما نرى أشهر القضايا التحكيمية التي عرضت في الستينات والسبعينات والثمانينات من القرن الماضي، سنرى أنه على الرغم من تنوع الأطراف، أي من وجود أطراف مما يسمى بالعالم الثالث وأطراف من أوروبا وأمريكا، فإن غالب المحكمين كانت لهم جنسيات أوروبية وأمريكية، وغالب المحامين أيضا كانوا من نفس الفضاء. لكن بمرور الوقت أصبح عالم التحكيم أكثر جاذبية للمختصين والدارسين والمحامين والطلبة من باقي بلدان العالم، وأدى ذلك تدريجيا إلى دخول هذا العالم من قبل أشخاص من آفاق ثقافية وحضارية ودينية أخرى. وشخصيا أعتقد أن نقطة التحول الكبيرة في مسار التحكيم هي فترة الثمانينات من القرن الماضي، التي شهدت حدثا قانونيا صرفا، وهو إصدار القانون النموذجي لليون سترال المتعلق بالتحكيم التجاري الدولي، ولكنها شهدت أيضا تحولا كبيرا في نظرة القوانين ثم في نظرة المجتمع القانوني إلى التحكيم. فبفضل هذا القانون جاءت موجة واسعة من تحديث التشريعات، وهذه الموجة الكبيرة من تحديث التشريعات لفتت نظر المشرعين والقضاة والمحامين إلى أهمية هذا الجانب، وهو مسألة فتح مجال التحكيم أمام وجوه جديدة، أمام دماء جديدة، أمام رؤى جديدة وثقافات جديدة. وأدى ذلك إلى حركة واسعة وكبيرة تنوع بفعلها المشهد التحكيمي بشكل غير متوقع. أولا من حيث أصناف المتدخلين في هذا العالم، نلاحظ أن التحكيم اليوم صار أكثر تنوعا من حيث الجنسيات. طبعا أصبح هناك محكمون من كل أرجاء الكرة الأرضية، مع تواجد مستمر ومكثف للمحكمين ذوي الأصول الأوروبية والأمريكية، لكن أصبح المحكمون من آفاق أرحب. أصبح المحكمون أكثر تنوعا من حيث الأجيال، إذ أصبح عالم التحكيم مفتوحا ولو بنسبة ما أمام الشباب، وهو أمر لم يكن مطروحا قبل 40 سنة. أصبح التحكيم مفتوحا أيضا أمام النساء، وهذه أعتقد آخر موجات الانفتاح في عالم التحكيم، لأنه حتى في البلدان ذات التجربة التحكيمية العريقة ظل التحكيم رجاليا بدرجة أساسية، وعندما دخلت النساء إلى عالم التحكيم طرحت حتى بعض المسائل الفرعية، مثل تأنيث المصطلحات واستعمال مصطلح الرئيسة أو الرئيس، بريزيدان، محكم، محكمة. هل يجوز تأنيث المصطلحات؟ مسائل فرعية فرضها الدخول الفعلي للنساء في عالم التحكيم على الرغم من الصعاب. فالصعوبات تأتي من عوامل اجتماعية، ولكنها تأتي أيضا من قراءات قانونية كما حدث في بعض البلدان، حيث رفض إعطاء الصيغة التنفيذية لحكم تحكيمي شاركت فيه امرأة بدعوى أو بتعليل يقوم على مخالفة ذلك للشريعة الإسلامية. لكن وجود هذه العقلية المتحفظة من دخول وجوه جديدة وأصناف مجتمعية جديدة إلى عالم التحكيم لم يمنع من أن المسار ظل يسير في نفس الاتجاه، وهو مسار مزيد من التنوع وإلغاء أو رفع الحواجز أمام دخول هذه الأصناف الجديدة من البشر إلى عالم التحكيم. رغم كل ذلك تظهر بعض الدراسات المحدودة أو المجتزأة. قمت منذ فترة قليلة بدراسة تتعلق بصنف خاص من قضايا التحكيم التي عرضت على المركز الدولي لتسوية نزاعات الاستثمار الإكسيد فيما يتعلق بالقضايا البنكية فقط. وأظهرت دراسة القضايا وعددها 40 قضية عرضت على هذا المركز وجود تنوع حقيقي من حيث الأطراف، باعتبار أن أطراف هذه القضايا يأتون من كل أرجاء الكرة الأرضية دون استثناء. ولكن على مستوى المحكمين لاحظنا وجود تنوع حقيقي، ولكن مع هيمنة واضحة للمحكمين ذوي الأصول الأوروبية والأمريكية. بالمقابل لاحظنا أمرين يلفتان الانتباه. مقابل التنوع المقبول بدرجة ما فيما يتعلق بالمحكمين، نلاحظ السيطرة كلية لمكاتب المحاماة الأوروبية والأمريكية التي تستحوذ على نسبة عالية جدا جدا من القضايا التي يقع فيها تمثيل الأطراف أمام هذا المركز. ولاحظنا أيضا أن اللغة الإنجليزية تكاد تصبح اللغة الوحيدة للتحكيم، من 40 قضية هناك 3 قضايا فقط استعملت فيها اللغة الفرنسية، وهناك عدد صغير جدا من القضايا التي استعملت فيها اللغة الإنجليزية مع لغة أخرى، وأساسا هي إما الفرنسية أو الإسبانية. إذن أصبح عالم التحكيم أكثر تنوعا من حيث الأشخاص والمتدخلين، وبالمقابل نلاحظ تضييقا من هذا التنوع أو تقلصا في هذا التنوع من حيث أدوات العملية التحكيمية. فاللاعبون الجدد من محكمين ومحامين ومستشارين على الرغم من تنوع ثقافاتهم ولغاتهم وأديانهم أيضا، فإنهم يميلون جميعا إلى استعمال اللغة الإنجليزية في غالب القضايا التحكيمية، وأيضا في إدارة القضايا التحكيمية وفق نفس المنهج الإجرائي الأنجلو أمريكي المستمد من تقاليد الكومن لو، ويبتعدون تدريجيا عما ألفوه في محاكمهم الوطنية التي تعتمد أنظمة إجرائية مختلفة. إذن ثقافة التحكيم أو أدوات العملية التحكيمية أصبحت أكثر وحدة وانصهارا مقابل تنوع من حيث الأشخاص والمتدخلين. هذا التنوع تعزز من خلال بعض القراءات القضائية المعتدلة لهذه المسألة. فأشير مثلا إلى قضية طرحت في إنجلترا وأثيرت بمناسبتها نقاشات عميقة جدا فيما يتعلق بتلاؤم منطق التحكيم مع منطق الاتفاقية الأوروبية لحقوق الإنسان والاتفاقية الأوروبية بوجه عام. ففي قضية جيفراج ضد هشواني، ميزة هذه القضية أن الطرفين اتفقا على أن يكون المحكم أو المحكمون منتمين إلى الطائفة الإسماعيلية، ليس فقط أن يكونوا من ديانة معينة بل أيضا من طائفة محددة. حين عرضت مسألة تعيين المحكم على المحكمة وقع جدال بين المحاكم الإنجليزية نفسها، بين محاكم تقول إن اشتراط ديانة معينة في المحكم يتخالف أو يخالف المبادئ التي يقوم عليها الاتحاد الأوروبي والاتفاقيات المنشئة للاتحاد الأوروبي التي تقوم على مبدأ المساواة بين الأشخاص وعدم جواز التمييز بينهم على أساس الدين. لكن في نهاية المطاف وبعد نقاش استمر مطولا انتهى الرأي إلى أن مبدأ المساواة لا يتنافى مع احترام مبدأ الرضائية والتعاقدية في التحكيم، وأنه لا يوجد تعارض بين اشتراط ديانة معينة والقوانين والاتفاقيات الأوروبية. فكان ذلك في الحقيقة عامل تنوع للتحكيم من جهة، وعامل ضمان لاحترام إرادة الأطراف في التحكيم. ما أستطيع أن أنتهي إليه هو أن عالم التحكيم اليوم فيه درجة من التنوع على مستوى الأشخاص والمتدخلين، ولكن فيه درجة أكبر من الانصهار والتوحد أو الوحدة فيما يتعلق بالأدوات ومنهج الإدارة التحكيم، وحتى من حيث القواعد المنطبقة، باعتبار أن نسبة هامة من المحكمين يعلنون أو يضمرون أيضا تطبيق قواعد موحدة حتى على أصل النزاع، بحكم تغلغل فكرة تطبيق ما يسمى بالليكس ميركاتوريا في تمظهراتها المختلفة، حيث أصبحت تتفرع عنها مفاهيم فرعية: ليكس بتروليا، ليكس سبورتيفا، ليكس ماريتيما، ليكس إلكترونيكا وغير ذلك. فنلاحظ إذن أن منطق التحكيم يسير نحو مزيد من الانصهار والوحدة مقابل مزيد من التنوع في ما يتعلق باللاعبين. ومع ذلك فالإحصائيات التي اطلعت عليها تقول إن التحكيم ما زال بدرجة كبيرة محل لنقل تواجد مكثف من فاعلين، من محكمين، محامين من عالم معين وهو أوروبا الغربية بالأساس وأمريكا، مقابل انفتاح تدريجي. ولكن درجة التنوع المثالية أعتقد أننا لم نبلغها بعد، وأنه ما زال هناك عمل ينبغي القيام به من الجانبين حتى يصبح عالم التحكيم أكثر توازنا وأكثر تنوعا، دون أن يمس ذلك من جودة الخدمات التحكيمية. شكرا على إصغائكم.
Our third and final speaker is Xin Bao, who's very familiar to many of us as an independent arbitrator, a CEDAR accredited mediator, a New York qualified Mandarin speaking attorney with more than 15 years working in international arbitration in London, New York, and Hong Kong. She's also served as arbitrator, presiding sole, co-arbitrator, emergency arbitrator, I'll slow down for the translator, and a number of arbitral institutions and their rules, UNCITRAL, ICC, SIAC, HCAC, AI, AC. Ms. Bao's involvement as acting arbitrating counsel for corporate, state-owned, and states themselves in a range of disputes in sectors including tech, IP, licensing, shareholder disputes, real estate, finance, construction, and general contract. Ms. Bao serves as Vice President of the ICC Court of Arbitration, Paris, and very impressively, from 2010 to 2016, Ms. Bao served as a very successful Secretary General of the Hong Kong International Arbitration Center, where she managed hundreds of arbitrations before tribunals in Asia, with obviously a very strong focus on China. During her tenure, HKAC was recognized in several fora, and in particular, most frequently used arbitral institution outside of Europe, quite an accolade, most improved institution, and ranked third best arbitral institution worldwide by the 2015 International Arbitration Survey conducted by Queen Mary. She also speaks and writes on topics of international arbitration as co-author of Oxford University Press's A Guide to the HKAC Rules. She's an honorary senior fellow of the British Institute of International Corporate Law and a frequent lecturer. She's taught in Hong Kong and elsewhere. And I turn you over to Ms. Xin Bao.
Thank you very much. I would like to express my sincere gratitude to the organizers of this excellent event who have made this a seamless journey from invitation to here today. As someone who used to organize many conferences in the past, I wish to express a special thanks to those who have worked tirelessly behind the scenes and, as I understand, throughout the night to make this morning possible and today possible. Today I wish to spend a bit of time with you in terms of discussing the outcome of diversity and gender equality efforts made to change the landscape of the international investment arbitration regime, both from a structural and a substantive perspective, as embodied in the new Dutch model BIT. This is as close to a blank sheet of opportunity or a piece of paper for investment arbitration to break out of the square box that Toby Landau had mentioned in terms of commercial arbitration that investment arbitration could do in recent years. And through the lens of this innovative new Dutch model BIT, I will gaze into the proverbial crystal ball and make some observations of the impact of this model BIT and how it might have an impact on the investment arbitration regime. In March of this year, the Dutch government released the final version of the Dutch model bilateral investment treaty. In the context where we have seen a significant backlash in the investment arbitration system and where legitimacy of the system is being questioned, this model BIT is an attempt to address some of the criticisms raised and reflect a shifting tide in the international arbitration system. Indeed, this model BIT places a marker on the evolution of the regime. The new model BIT represents a policy shift from the former pro-investor treaty to one which places greater emphasis on the rights of states parties to regulate the activities of investors to achieve legitimate policy objectives. There are a number of changes to the status quo which may in due course serve to limit protection currently afforded to both foreign investors investing in Netherlands and to foreign investors investing in other states using Dutch corporate vehicles. And relevant to our discussion on diversity today, there are two innovative changes that I wish to focus on, one being the constitution of the tribunal, and two, the inclusion of gender equality in the operative sections of the BIT. First, the structural change. Pursuant to Article 21 of the Dutch Model BIT, all arbitrators are appointed by the appointing authority. This means that the Secretary General of ICSID, as well as the Permanent Court of Arbitration, will appoint the entire tribunal in any matter brought before the Model Dutch BIT. This bold move is a first of its kind under any arbitral rules of any major arbitration institution in commercial arbitration and under any appointment process in a BIT or other mechanism in investment arbitration. Taking away the party's fundamental right to appoint an arbitrator, the Dutch model BIT hands its right to the appointing authority for sake of ensuring independent and impartial adjudication, as first argued by Jan Paulsen. While some will argue that this will compromise the user's confidence in arbitration, the desire for neutral adjudicators has won the debate in the negotiation in this particular provision. The Dutch government does not stop here, however. In establishing the procedural framework for constitution of the arbitral tribunal, arbitrator qualifications were detailed. The inclusion of certain requirements is not unique, as other BITs have stipulated this in the past. However, pursuant to Article 22 of the Dutch Model BIT, the arbitrators must be qualified to be appointed to judicial office in their home jurisdictions or be jurists of recognized competence. And further, the appointing authority shall, quote unquote, strive for gender and geographic diversity. The inclusion of this language was incorporated as suggested by certain interested bodies which encouraged the Dutch government to ensure that the arbitrators are appointed from a diverse background, taking into account gender, geographic representativeness, and expert in areas of environmental, social, and human rights law. Article 25 then describes that when appointing the arbitral tribunal, the appointing authority must ensure that the members of the tribunal, either individually or together, possess the necessary expertise in public international law, which includes environmental and human rights law, international investment law, as well as the resolution of disputes arising under international agreements. Now, focusing on the insertion of this language, shall strive for gender and geographic diversity. It is under this mandate where I suggest that diversity will germinate in the investor-state regime. Already in commercial arbitration space, the arbitration institutions are making headway in shifting the balance of gender equality. The efforts institutions have made in realigning statistics and discovering talent in a broader pool of arbitrators is palpable. Many institutions now proudly display their statistics of female arbitrator appointments and have revised internal processes to ensure that female arbitrator candidates are considered in the appointment of arbitrators. Speaking from my experience at HKIC and what I know of my successors' efforts, institutions have made great strides in ensuring that there is fair representation of women on panel of arbitrators and that lists of arbitrators sent to parties will include a fair representation of women, and that gender statistics for appointments are collated and made public. Now you may ask, these efforts, are they cosmetic because they are efforts in part of a broader affirmative action effort, or is there an actual causal connection between the diversity of tribunal and quality of decision making? A February 2015 McKinsey report indicated that diversity thinkers challenge one another and improve quality or perhaps robustness of reasoning important for awards. Further, when the survey participants of the Queen Mary White and Case survey were asked, what effect do you think diversity across panel of arbitrators has on the overall quality of the tribunal's decision-making, 40% of the respondents indicated that there was some improvement in quality, and 18% indicated that there was significant improvement in quality. With this general impression by users that there is some positive impact on diversity over quality of tribunals' decision-making, the momentum of institutions to proactively balance the gender equation, and now with such language boldly directed in the Dutch model BIT, the designated appointing authorities in the Dutch model BIT, and indeed of many other BITs, the PCA and ICSID, will invariably make efforts to continue the trends of gender and geographic diversity as we see in the appointments made at other commercial arbitration institutions. Second, the Dutch model BIT imposes responsibilities on both the investor and the state in relation to corporate social responsibility, which includes gender diversity. The Dutch model BIT makes reference to international standards that the parties should strive to comply with. Article 6.6 of the Dutch model BIT commits parties to cooperate as appropriate on investment-related sustainable development matters of mutual interest in multilateral fora. With an aim to promote sustainable development, the Dutch model BIT encourages the creation of favorable conditions for responsible investment in its territory that contribute to sustainable economic development. In this regard, there are specific references to the G20 guiding principles on global investment policy making, the Paris Agreement, the fundamental ILO conventions, and the University Declaration of Human Rights. Such language raises the level of consciousness by both the investor and the state in terms of the standards expected on both sides when seeking to invest or seeking to attract investment on foreign grounds. Along with this recognition of the international expectations pertaining to sustainable development is the reference to international corporate social responsibility standards. Specific references to the international framework on business and human rights, and such as the UN Guiding Principles on Business and Human Rights and the OECD Guidelines on Multinational Enterprises, expresses a commitment to the strengthening of this framework as well as encourages investors to adhere to the principles espoused in those international documents. Now, social responsibility of corporations have not traditionally been addressed in most international investment agreements. Over the years, however, the situation has changed. In fact, one early example of the recognition of the connections between foreign investment and social development can be found in the 1981 Agreement for Promotion, Protection, and Guarantee of Investments among member states of the Organization of the Islamic Conference. The preamble expresses Islamic states' conviction that investment is one of the major areas of economic cooperation these states through which social development therein can be fostered. The preamble also sets out that the agreement's aim is to develop a favorable climate for investments so that the economic resources of Islamic states can be used in a way that serve their development and raise the standard of people of living for their people. And Article 3 of this agreement states that the parties shall endeavor to open up investment opportunities in order to foster the social development of the host state and at the same time achieve a profitable investment return for the capital. Countries have recently reviewed or are in the process of reviewing or developing national models and are now taking into account CSR obligations. Take India as an example. Chapter 3 of the India Model BIT lists investor obligations, which uniquely extends beyond the traditional obligations, also requiring investors to voluntarily incorporate internationally recognized standards of corporate responsibility. Noteworthy in this language is that India has clearly not felt sufficiently confident to reference the Indian standards of corporate social responsibility. And while this requirement that foreign investors adhere to a different standard from domestic investors has potential to cause trouble by introducing an internal incompatibility in Indian BITs with the public international law concepts of national treatment and non-discriminatory treatment. This novel provision nonetheless appears to encourage foreign investors to support various social causes in and important to the host state. Now, the CSR obligations are clear in the Dutch model BIT, and in fact, under this BIT, makes specific reference to gender equality. And for sake of time, I will just paraphrase this provision, which describes the importance of the contribution by women to economic growth in their participation of economic activity, including international investment. And where beneficial, the contracting states shall carry out cooperation activities to improve the participation of women in the economy, including international investment. Now, this singular provision that recognizes the importance of diversity in the global investment regime is key. Indeed, the impact of the Dutch model BIT could be a game changer both in the structural and policy framework of the investment arbitration system and the rights and obligations of states, but in particular, the obligations of investors in relation to gender equality. According to the statistics by UNCTAD, Dutch BITs are the second most frequently invoked BITs globally, suggesting that they fulfill a key function in facilitating international investment flows globally. And in fact, they have served as the gold standard in terms of model BITs. However, following the criticism from certain NGOs and the public opinions that BITs are too heavily skewed in favor of investors, the new Dutch model BIT departs from the tradition to a certain extent and aims to create a more balance between the rights and duties of the host states and investors. As the Dutch government begins to renegotiate BITs with states outside of the EU, such as Turkey and the UAE, and replace its BITs with states and also establish new BITs with Qatar and Iraq to start with, we will most certainly see some of the newly progressive language in the final BIT being expressed in these new BITs. Thereafter, with time, no doubt, the impact of such language will be felt. Now, while progress may be slow and may require patience, without action, there will be no progress. Thank you.
Thank you very much. So, all causes, all moves, all reforms need good champions. And if any of you know Jackie, who's the Director General of the London Court of International Arbitration, she's made it her mission to increase the number of female arbitrators. And just to give you an idea, in 2017, the LCA arbitrator appointments were 97 out of the 412 arbitrators appointments, so about a quarter, and that was an increase of 3% from 2016. But she also noted in a subsequent speech that today 25% of all arbitrators appointed in LCIA are women. This was last year. But where appointments are made directly by the LCIA, that percentage rises to 43% being women. If they can put up just the 3 slides from Cairo, we're going to take questions. And while they're putting up those 3 slides, I wanted to use those because Ms. Dahlia wasn't able to join us, but she did include some very useful slides with regard to the appointment of women out of the Cairo Regional Center. Now, obviously, for local mediations around the world, diversity can be different. It can be, for example, in Saudi Arabia, the arbitrators are often Saudi. The question is there real diversity among those, both in terms of gender, age, or career of origin? Because there are a lot of arbitrators around the world who may or not be counsel. But in Saudi, it's certainly the case that Saudis do appoint Saudi arbitrators, but they typically are older lawyers that are male